felt that Occupy Astoria should really do something to support the work of all these groups and organizations that have been laboring for years on the issue of stop and frisk. The policy was implemented in 1994. Many people have worked for a decade or more on this issue. Things have, reached a critical mass, and we thought that we could support them in what they're doing, particularly because our elected representative for this district, Councilman Peter Malone, is the chair of the Public Safety Committee, which oversees the police department, and Councilman Malone has not signed on to the Community Safety Act, which would put the brakes on some of these practices. The other thing that when I was looking into this issue that was very surprising was to find out that in our district, the precinct number 114, in the year 2011, there were 10,343 stop and frisks in our precinct, which was very shocking and surprising. Many of us live here and have no idea because we're not targeted by these practices, but the number is huge, for our neighborhood, and we felt that ethically and morally we have to try to do something about it. And this number comes from an interactive map that's on the stopandfrisk.org website. And on that website, you will also find a report called Stop and Frisk: The Human Impact. There's hard copies over there. It's on the website. And Nahal Zamani from Center for Constitutional Rights, who's sitting right over here, did all the initial interviews for that report, worked on a draft, I guess, at least the first draft, collaborated with other people at CCR, and I think has done a really excellent job on that report, and has also helped us put this program together because she was the contact for most of the speakers. She put us in touch with the people we needed to speak to in order to set up this event. So thank you, Nahal, and also your coworker, Mijan, who helped us while you were on vacation, finalizing some of the speakers. So we want to thank her as well. So I'm going to turn the program over to Michelle Rhonda, who's going to facilitate.
Hi, everybody. Welcome. I ask you to join me in thanking Mary Ann for making this happening, because without her graceful and powerful organizing, I don't think we'd be here tonight, so thank you. Many people contributed to tonight, but I think you made it happen, so thank you. Christian, is Christian? Yeah, Christian. I don't know, do you want to take a moment to ask about...
Oh, sure. Hola. I don't know. I'm just going to say, if anyone, I'm going to say this in English first, so you know what I'm talking about. They asked me if anyone needed to translate to any Spanish speakers that were here. I could do that. Hola, mi nombre es Cristian, y si alguien necesita que yo traduzca, es posible. So, me dice si alguien no habla inglés.
But thank you, Christian,
no problem.
for being willing to comment.
Oh, sure.
We appreciate it. We're going to hear from 4 speakers this evening, whom I'll introduce in more detail when their turn arrives. But I want you to join me in welcoming them and thanking them for joining us. First is Ian Head from the Center for Constitutional Rights. Hi, Ian. Second is Yulsan Lim from the Justice Committee. Next is Jean Rice from Picture the Homeless. And Michelle Fay from the Immigrant Defense Project. My name is Michelle Rhonda, and I teach sociology at Marymount Manhattan College. I'm also fortunate enough to be at a college that still offers degrees to people who are incarcerated in New York. So I teach at Bedford Hills Correctional Facility, the maximum security facility for women in New York State. In preparing for my Introduction to Criminal Justice class, which I'll be teaching tomorrow, I had to reread some work by American University's Professor Jeffrey Ryman. And you may have heard of Jeffrey Ryman because he wrote a book that has become internationally known for its incisive critique of the inequalities in the United States. It's called The Rich Get Richer and the Poor Get Prison. And he wrote it in 1979, but it's just as apt right now where we stand, unfortunately, today as it was in 79. I wanted to begin with a little quote from his insights. They tend to ground me, but I think they're also quite relevant to what we're going to talk about today. Ryman wrote in 79, "A criminal justice system is a system of justice to the extent that it protects equally the interests and rights of all, and to the extent that it punishes equally all those who endanger these interests and violate these rights. To the extent, though, that it veers from these goals, the criminal justice system is guilty of the same sacrificing of the interests of some for the benefit of others that it exists to combat. It is, therefore, morally speaking, guilty of crime." I thought it was a good way to orient us to the idea that there's something fundamentally wrong, and we've all known that there's something wrong for a long time. So his words are relevant to many of the concerns that we share in common, but particularly to questions of racism, inequality, and the criminal justice system. In late July, Occupy Astoria, Long Island City came together during our documentary series to watch a video from Michelle Alexander's insightful and rallying speech about her 2010 book, The New Jim Crow, Mass Incarceration in the Age of Color Blindness. It's basically about the redesign of the racial caste system in America. That's the sort of heart of her argument. Alexander argues that a formally colorblind criminal justice system is able to achieve racial discrimination in 2 steps. First, by granting law enforcement officials extraordinary discretion regarding whom to stop, whom to search, whom to arrest, and whom to charge for drug offenses, thus ensuring that conscious and unconscious racial beliefs and stereotypes will be given free rein. That's step 1. Step 2, the system denies that it operates in a racially discriminatory fashion and says, "Prove it to me. Bring me your evidence." Right? But no evidence is ever good enough for that system to admit it's intentional or unintentional discrimination. So the film and the book certainly can reignite anger and empower us with information. But as Marianne pointed out, we wanted more information about what's happening now and really what we can do to act, to take our anger and make it transform it into action. So without further ado, I'm honored to introduce the first speaker this evening to find out more about this action. And can I ask that you hold your questions until the end, until the last person's done, if possible. Ian Head is currently a legal worker with the Government Misconduct and Racial Justice Docket of the Center for Constitutional Rights, which we know more commonly as CCR. At CCR, Ian has spent time working on the stop and frisk case Floyd v. City of New York, as well as immigrant rights and prisoner support work. Ian has also worked extensively with the National Lawyers Guild, where he continues to train legal observers and help with legal support for mass protests. For that, we are grateful. I give you Ian.
Everyone. So, thank you for that introduction. It's definitely an honor to be here. I'm going to just kind of briefly run through the Floyd stop and frisk lawsuit, which I think most of you probably have heard of. Has anyone not heard of the Floyd versus City of New York stop and frisk lawsuit? Okay, a couple folks. So I'm gonna briefly run through it, and if there's more questions about the lawsuit itself at the end, you're definitely free to ask. We also have lead counsel in the case, Darius Charney, here in the green next in the hall, so you can also ask any, especially the technical legal questions that myself may not be able to answer. But in 2008, we filed a federal class action lawsuit against the City of New York, alleging unconstitutional illegal stops by the police and racial discrimination in those stops, so violations of the 4th and 14th Amendment. And what I really wanted to talk about today is kind of where the case is now and action steps, like Michelle was talking about, you know, how people can be involved, you know, how we can kind of move forward. I'll give a little background on just kind of, and then connecting it also to the fact that, you know, we're CCR, we're kind of this legal social justice organization, but, you know, a lawsuit by itself is really not that powerful. It really is important to be connected to, you know, movements, to people like everyone here, my fellow panelists. Like, it really needs the full, it's just a piece of the kind of bigger puzzle. And so when we filed Floyd, we filed it as a class action lawsuit because, I'm just going to read something from our complaint in the case. We filed as a class action because many members of the class are not aware of the fact that their constitutional rights have been violated and that they have the right to seek redress in court. Many members of the class are without means to retain an attorney to represent them in a civil rights lawsuit. Many class members who have been victimized by the NYPD's unconstitutional practices do not bring individual claims for fear of retaliation and reprisals by NYPD officers. There is no appropriate avenue for the protection of class members' constitutional rights other than a class action. And so we filed it in this way because there's just obviously there's hundreds of thousands of people's rights are being violated every year, and so this was the legal method to, you know, try and protect folks' rights. Floyd comes out of a case called Daniels, which was filed, I believe, in '99, Darius?
Yep.
Regarding stops and frisks, specifically the street crimes unit of the NYPD. And that case settled, and we got a couple in 2003, I believe, and we got a couple of things out of it, and the city agreed to do certain things like audit officers, stops, and meet with community groups, and provide quarterly data to CCR and the city on stops and frisks. But really,